Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Thomas D. Sawaya, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. In God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Morning, and welcome to this session of oral argument of the 5th District Court of Appeals. Certainly our pleasure to preside over the cases on the docket this morning. Let me introduce the panel to you. As you've heard, I'm Judge Sawaya, and to my right we have Judge Berger, and to my left we have Judge Wallace. We have two civil cases on the docket this morning. If you're here for Gotham versus Matthew or Ransom versus Ransom, those cases are no longer on the docket. Since these are civil cases, each side will be allotted 20 minutes. If the appellant wishes to reserve any time for rebuttal, let me know. We have a clock that will assist you in keeping time. So with that, we'll call the first case, Florida Superior versus State Farm. If you have any electronic devices, please turn them off so that we're not interrupted during the course of the oral argument. Okay, the appellant may proceed.
May it please the court.
Okay.
I'd like to reserve 5 minutes of my time for rebuttal.
Okay. All right.
Chief Judge, Your Honors, my name is Earl Higgs, and I represent the appellant, Florida Superior Insurance Company, who I may refer to as FSI throughout the argument. In this case, the trial court denied entitlement to attorney's fees for my client, relying upon this court's decision in Rural Metro versus Progressive. We believe the trial court committed error, and we're asking this court to reverse that decision with directions to the trial court.
What recovery was had in this case that would entitle you under 627-428-1 attorney's fees?
I'm sorry, I have a little cold, so I coughed. I didn't hear your question.
Okay. What recovery, other than a piece of paper that says summary judgment granted, what recovery did FSI receive?
Well, if the court is aware, in this case, the State Farm, what they did was they filed a deck action against my client.
Mm-hmm.
Their position was the services that my client provided, which were mobile x-ray services, were unlawfully rendered.
The judgment was in the deck action, or was that in the PIP suit?
In this case, in the same case.
Okay, right. No, but there were two cases, and the cases were combined for discovery purposes only, correct? Okay, so the judgment was recovered. When you say this case, are you referring to the deck action, or are you referring to the 37 patients that had received alleged PIP benefits?
In this case, they filed a deck action.
Which case?
The case that we're here on today. They filed a
I'm talking about which underlying case, though, were you talking about where you received the judgment? The deck action or the PIP case?
The deck action.
Okay.
Okay. So we received the underlying judgment. If you allow me to explain, please. What we're here on today is the deck action.
Right.
They sued our client. Basically, the gist of their complaint was you didn't render lawful services by the mobile x-ray services that you provided.
And let me be clear, that was, the deck action was based on the 37 patients.
Correct.
And those 37 patients, FSI there was never any suit in those 37 cases, correct? Because
Correct.
the statute of limitations had run.
Not correct. There was no suit because there's no, well, first of all, there's no record evidence why those FSI never filed a PIP claim on any of those 37 patients.
Okay, so there was never any ruling that said that payment as to those 37 patients was unlawfully withheld by State Farm, right?
Correct.
There was never any recovery on those 37 patients, nor could there ever be any recovery on those 37 patients because there was no suit was filed because the statute of limitations has run, which was your client's argument as to why summary judgment should be granted in their behalf, and the deck action.
Correct.
So there was never going to be any recovery at all on those 37 patients that were the subject of the DEC action, correct?
Well, that's not entirely accurate because you have to take a step before that. Before we get to the summary judgment where we argued, look, they have sat on the case, they've not diligently prosecuted the case, they've done nothing. Now the statute of limitations has run.
Well, that's not their fault. That's your fault, or your client's fault, for not filing a suit. That doesn't have anything to do with what State Farm does. They can do whatever they want in their case. Your responsibility, or your client's responsibility, if they want a payment, is to, and they're not getting it from State Farm, is to file suit in those 37 cases, is it not?
Respectfully, I disagree because, recall, there were several PIP claims that my client did file, and those claims were filed. Those are the ones that were resolved for discovery purposes.
But those weren't the subject of this DEC action.
Correct, but let me explain, please. We filed lawsuits on those cases. Those cases, they actually did resolve. So, for whatever reason, my client decided which ones they wanted to file on and which ones they didn't. It wasn't until State Farm hauled us into court and made us have to defend ourselves. So what happened was, they filed their DEC action, we're litigating this case. Then they move on, and they say, look, you know what? We think these services are unlawfully rendered. And so we go to summary judgment on that. The court says, no, they agree with us. They deny the motion for summary judgment. So what we recovered is, at that point, we still maintained our right to pursue benefits if we had to. We could choose to or not to.
By denying summary judgment, you're saying that the court made a specific ruling that State Farm was wrongfully withholding benefits? Where in the record is that?
No, that's not what I'm saying. What I'm saying is, by denying the motion for summary judgment, that allowed us to continue to proceed, if we choose to do so, with filing a lawsuit if we needed to. It left that option open for us to still be able to file a PIP suit, because at that point, the statute limitation hadn't run. So when the court denied their motion for summary judgment, that still meant that if my client the next day wanted to go file a PIP suit, they still could have.
But did not.
They did not, but we still had the ability to do so. And so I would submit that is a recovery, because in defeating them, from allowing them to, if the court had agreed with them, we would have been done right at that point. And we went.
But you didn't file suit. You recovered nothing. You recovered nothing other than a piece of paper, which the court ruled in granting that motion, your motion for summary judgment, that because you had not filed your claims within statute of limitations, the issue was now moot, and the court lacked jurisdiction to hear the case with regard to these specific 37 patients. That was the sum total of it. And so because your clients failed to do something, which you just said they could have done within the statute of limitations, but for whatever reason chose not to, because they failed to do something, that State Farm should have to pay your attorney's fees. I'm finding that a bit difficult to swallow.
We didn't fail to do anything. They dragged us into court. They said, look, you know, we have a question about whether we are obligated to pay under the PIP statute these remaining 37 benefits. My client can choose to file a suit or not choose to file a suit, but they dragged us into court, forced us to have to defend ourselves, and that's what this court's decisions have talked about in Holiday versus Nationwide Mutual. The purpose of 627-428 is to reimburse successful insurers when they're dragged into court and forced to have to defend themselves.
And you recover something. You recovered nothing.
Well,
but a piece of paper.
Well, I believe our recovery was being able to still proceed, and some of the cases talk about it. The fact that you defeat their DEC action allows you to still continue. It's not over at that point. I still have a day to fight. And so because we defeated their motion for summary judgment on the lawful services rendered for the mobile x-rays, we still were able to stay in the fight. At that point, They are the ones that sat on the case, they did nothing, they being State Farm, they did nothing, they let the statute of limitations run. We then amend our affirmative
They
defenses.
let the statute of limitations run. Were they supposed to file suit against themselves? I mean, they let the statute of limitations run?
Well-
How is that possible? How can you stand there and say that State Farm let the statute of limitations run on a suit that was your obligation to file on? And I say you, meaning your client.
Sure, but because they started the fight. If my client wanted to file the suit in the beginning, they did in some of the cases, and there could be a multitude of reasons why they didn't file suits on the other cases. That's not a part of the record. We don't know why that is as we stand here. However, when you start the fight, and you drag me into court, and you make me have to defend myself for 5 years, that's what the purpose of the statute is about, because it's no question that this case fell within the scope of 627 and 736, the PIP statute. That's what the case is about. They had a question regarding payment obligations regarding whether they should have to pay these mobile x-ray services or not. So we fall within the purview of the statute, 627-428. I submit, I understand the court disagrees what the recovery was. We then get a judgment in our favor.
So you're saying that simply because they filed a deck action prevented you from proceeding or filing suit as you would have done within the statute of limitations?
No, I'm not saying they prevented us from filing a suit. I'm saying they dragged us into court.
Well, were you able to properly file these lawsuits within the statute of limitations before they filed their deck action or not?
Yes, some of them were, and those were the ones that got resolved.
And then, okay, and then they got resolved. And then there were some that the statute of limitations had already run before the deck action was filed. Is that right?
No. Several of the lawsuits got filed. My client decided to file them for whatever reason they wanted to file on those. Those got resolved. Statute's still running. We go to summary judgment, where the court denies their summary judgment on the lawful rendering of the services. Statute is still open at that point, okay? If they win, then we're done right there. My client can never file any PIP lawsuits, but we prevail, okay? So that's why I submit that's the recovery, because we prevail. We allowed ourselves to stay in the fight, okay? Now, my client, again, it's not a part of the record, could have chose to file on these other claims, but at that point...
I guess I'm a little bit confused. Stay and fight what? Because if the statute of limitations had run on the remainder of the cases, what was there to fight?
No, what I'm saying is, once we defeated that motion for summary judgment on lawful services, the statute was still
You
open.
defeated the motion for summary judgment because the trial court determined that the argument was with regard to whether the services were unlawfully rendered, that was a question of fact that needed to be decided at a trial. And because there were disputed issues in the case, the trial court correctly denied summary judgment. I mean, that's not a recovery. And it doesn't preclude you from then filing these other lawsuits if you wanted to file them.
Yeah, and I want to make it clear, I'm not saying that my client was precluded from filing lawsuits. That's not a part of the record. That's never been our argument. What I'm saying is, when the court denied their motion for summary judgment, again, be it disputed issues or fact, whatever the case may be, we still were allowed to stay in the game. If we had lost at that point, it would have been over for us. We would never been able to recover, but because the trial court denied the motion for summary judgment, we were able to stay in the game. The statute was still running. At that point, had not run yet, rather. At that point, is when, again, they did nothing to diligently prosecute their deck action. They did nothing to do it. They sat on it. The statute of
They
limitations...
filed a motion for summary judgment.
Okay, but at that point, but they're the plaintiff. They got to do something at that point. Set up for trial, do something. I mean, it's the plaintiff's obligation to move the case forward. They did nothing. They sat on it, and then when the statute of limitations ran, it's when we amended our answer from the defense to raise it as a defense, and we said, look, court, they can't win now. They've lost the ability to do so. They can't...
Can you? Neither can you, because you've lost the ability to file on those 37 patients. You can't win either.
Correct, but it's...
So, in order to get your fees, then I don't see, I fail to see it, I'm sorry. I fail to see the recovery that was had other in this case. I mean, if you had filed suit on those 37 patients and gotten some sort of judgment in your favor on those suits, if you had pursued what this inquiry that the court had indicated needed to go forward. If that had been pursued, perhaps. But what I see is your clients allowing the statute of limitations to run, using that as a defense in the deck action, and then having the court say, yeah, I agree with you, there's no controversy anymore because these 37 patients are not at issue because you didn't seek anything on them, and therefore, I'm dismissing the case. I'm granting the summary judgment, dismissing the case. I don't have jurisdiction over an issue that's moot.
Well, but again, I think respectfully, you're viewing it through the lens of essentially their argument, which is the court's prerogative, obviously, but the issue... I
spent a lot of time trying to find where on earth the recovery is for your clients in this case. I just don't see it.
I mean, but there are cases that talk about the fact that when you defeat a deck action, and when they're not on the merits, you are still entitled to fees. The Gorilla concrete case that we talked about in our brief, the Montes case where there's two lawsuits going on. The plaintiff filed one lawsuit, then the defendant files a second lawsuit in circuit court. The court dismisses that case in circuit court and says, look, plaintiff, you are entitled to fees because that case got dismissed on a jurisdictional type issue as well. I mean, there's several cases that talk about that and discuss the fact, and that's what we have here.
The statute of limitations run on the 36 or 37 cases. When was that? Do you know?
I don't know the exact date, right?
Before or after the deck action was filed?
Oh, after.
How long after the deck action had been filed?
If I'm not mistaken, I think we were in litigation for about an additional 2 or 3 years after that.
So while the deck action was pending, you still had these 36 or 37 claims that were viable because the statute hadn't run up to a certain point. What about the deck action that prevented you from filing the lawsuit on those 36 or 37 cases within the statute of limitations? The deck action didn't prevent you from doing that, did it?
Again, the deck action never prevented us from filing any lawsuit.
So the cases were viable, the statute had not run, they filed their deck action, and then for 2 or 3 years into the deck action, you still could have filed those suits because the statute hadn't run. Is that right?
Correct.
And then you used the statute of limitations as a basis to get the ruling from the trial court that their deck action had also expired as well.
Correct.
So your position is...
You think that's a recovery?
Again, the basis for my reason for saying that there is a recovery is because of the... There can't be a recovery because your client sat on their rights and didn't file the lawsuits within the statute of limitations as they could have. And the deck action didn't have anything to do with that. At the time they filed the deck action, those lawsuits were viable lawsuits, and within the statute of limitations, that's why they filed it. And then as the deck action went on, the statute of limitations eventually ran. But that's not their fault, that's your client's fault, right? And then the trial court said, okay, well, I'm issuing summary judgment because the statute of limitations is run, and therefore their deck action goes by the wayside. And so that's basically what the trial court did. So there's no recovery on your part because the statute had run, but not because of any fault of theirs, because of the fault of your clients. So... But again, I think the issue is,
And you keep saying that, well, it allowed you to proceed. You proceed with nothing because you couldn't proceed because your clients let the statute of limitations run.
Well, no, proceed at that point. At the time the trial court denied the motion for summary judgment, there was still time left under the statute. So we still had time on the clock, is what I'm saying.
They didn't pursue it, for whatever reason.
Correct, they did not.
All right.
So basically, you're saying that there's an entitlement and a deck action for you to stay any statute of limitations running on cases that you get to handpick and determine whether or not they applied to the deck action. And so after the deck action is over, then you get to choose which ones to go forward on. Is that correct?
No. Well, first of all, my client can decide to file 1 PIP suit or 0 PIP suits. So to that extent, I follow you.
Within the statute of limitations?
Obviously, everything's within the statute of limitations. I see I have 2 minutes, so I'd like to...
You got a couple minutes left, you want to reserve them, so...
would you like to respond to a question, or...
Sure,
Okay.
go ahead.
So we still have My client can file one lawsuit or no lawsuit within the statute of limitations period. So I follow you there. And so my position here was that we still had time once the denial of the summary judgment took place. And so it was at that point the statute ran. After that point, the statute ran. And so
Okay, so you're basically saying then that at least you had the right for a short period of time to file the lawsuit, because
Correct.
that's what the deck action, the decision of the deck action gave you. But
Correct.
you didn't file the lawsuit, your clients didn't.
They did not.
Okay, you reserve the rest of your time. All right.
May it please the court, Ken Hazuri here for State Farm. I don't have a whole lot to add because I can tell that the court has reviewed these things carefully, the briefs carefully, and the facts of the case carefully, and have a good grasp on the issues and what happened. Judge Berger, your chain of reasoning and the questioning is exactly what we raised in our brief, and it would be hard for me to add much to it. I think you're 100% correct in the way you're approaching this and looking at it. I will say that, once again, there's been direct questioning on...
So, do you think when the statute says recovery, that that's limited to money?
Not specifically to money in all circumstances, no.
It could be it could be a declaration that there's coverage. Would that be a recovery?
It depends. In a third party, okay, if there's an insured who's sued by a party on a third-party claim, and then they file, and their insurer doesn't cover them for some reason, and there's a deck action that arises to determine a third-party duty to defend in coverage, yes, in that circumstance, if the insured ultimately gets coverage or prevails in that case, there's a recovery of coverage.
Okay.
But on a first-party claim, and this is your decision in Mazzaghi, what's been happening in these PIP cases is to avoid demand letter requirements or something like that. The plaintiffs have technically not been suing for benefits, and they just say, we want a declaration as to whether there's coverage, PIP coverage or medical payments coverage. That's exactly what happened in Mazzaghi.
It's the insurance company that files a deck action claiming that there is no coverage, and court declare whether there is. And then the court says, yes, there's coverage. Wouldn't that be a recovery?
In most cases, yes.
That's a first-party action too, isn't it?
Well, yes, that's correct.
Okay.
In a case, for sure. In a PIP case, I'm not sure.
I want to stretch the concept to the point where trial court says, well, statute of limitations is run on your deck action, so you can't proceed. And then it's amazing to me the trial court would say that, but then they say they still had some time left to file their lawsuits, but they didn't. I don't understand how that could happen, but that's what his argument is.
Correct. The only, where I was going for your questioning, Judge Soroya, was there's been direct questioning on where was the recovery in this case, and the best that's been offered...
$1 million question, where is the recovery?
That is.
If we can find it, I don't...
It doesn't exist. The best that was offered is there was a motion for summary judgment ruling where the court said there's issues of facts, so go to trial. That's not a recovery. It's not even arguably a recovery. And then the other thing I would add is they raised this issue. Not only did they not file on the 37 claims when they could have easily filed a counterclaim, they came in and affirmatively raised the issue and said, the statute of limitations has expired on our own claims, so there's no controversy.
Just to change the facts a little bit, what would have been the position on the recovery issue if the trial court said, your lawsuit can't proceed, your deck action can't proceed because statute of limitations is run, but somehow or another they were able to file a few of the lawsuits anyway, saying that cleared the road for them to go ahead and file. Would that have been a recovery?
No, because this was a deck action to determine payment of PIP benefits. Coverage was never put at dispute.
All right, I got you.
You see what I'm saying? So if they recovered benefits in those PIP suits, then that's a recovery.
The trial court said, well, you just can't, we're not going to, you want a declaration that there's no coverage, and we're not going to give it to you, and that opens the door for them to file whatever remaining lawsuits they filed, and they did file them in time. Now, how that could have happened when the trial court said the statute of limitations run, I'm not exactly sure, but in that event, wouldn't there be some sort of a recovery?
In your hypothetical, Your Honor, you put a...
Could have been, right?
You couched the deck action in terms of coverage,
Right.
so that's not this deck action.
right.
The coverage wasn't in dispute in this deck action.
In
so-
essence, though, by filing a motion for summary judgment indicate to say that this, because the statute of limitations has run on all these 37 claims, and therefore there's really no issue in controversy, that it's moot, and the court should dismiss it. What FSI has done is then precluded the court from considering that there is coverage. You are required to cover. So we don't have a ruling of no coverage, and we don't have a ruling of coverage at all.
And Your Honor, I would agree with you, but tweak your statement a little bit. By doing what you just described, FSI precluded any ability of the court to rule that they were entitled to recover PIP benefits. And I wouldn't couch it in terms of coverage, I'd couch it in terms of PIP benefits. If they want, they reframed the issue for them, the court said go to trial, there's issues of fact, they could have litigated whether they were entitled to PIP benefits, and if they recover them, there's a recovery, and they get their attorney's fees. They decided they didn't want to do that, and based on their own unilateral failure to timely file suit on the 37 claims, came in and said the statute of limitations is run, so there's no more controversy, so Judge, you can't rule that we're entitled to PIP benefits.
I think and counsel will correct me when he comes back up if I'm wrong, what he was saying was after the original motion for summary judgment, where your client's motion for summary judgment, after that was denied, they still had time to file, but didn't. And then later on, the statute ran, and that's when they filed their motion for summary judgment.
I think that's what he said. I think if you review the transcript of that summary judgment hearing, that was State Farm summary judgment, where the court ruled there were issues of fact, I think they actually orally raised the statute of limitations argument in that hearing. So I think they started raising at that point. So at the time of that hearing, the statute might have already expired. And answer to your question, Judge Sawaya, I looked at the record real quick on page 4 of the motion for summary judgment that they filed, saying the statute had expired. They said the last bills or dates of service were October 5th, 2006, so if you rolled forward 5 years, that would take you to October 4th, 2011. So we could compare that to when the summary judgment hearing was filed and all that, and get the answers to those questions for you.
I don't think we have any more questions, thank you.
Okay, thank you.
Just to piggyback on something that Your Honor said, you're aware the case law is clear that recovery is not limited to money damages, which is why we raised the argument with regard to the recovery being, still being able to fight at that
It'd have to be
time.
an incredible stretch of the imagination for us to say that there would be a recovery under the fact and circumstances of this case. I mean, and I just don't know that the legislature intended that when they wrote the statute. I really don't.
Okay. For the reasons that I've presented today, we'd ask the court to reverse the decision of the trial court and enter a judgment of attorney fees in our favor.
Thank you very much.
Thank you.